Justice Alito has our opinion this morning in Case 147955, Glossip versus Gross.
This death penalty case presents two questions. One is a legal question, whether a prisoner who challenges the constitutionality of a state's method of carrying out a death sentence must identify an available alternative method that involves a substantially lesser risk of pain. The other is a factual question, whether a particular drug called midazolam that is used by the state of Oklahoma in carrying out a death sentence will render a prisoner unable to feel pain. The death penalty presents a controversial and emotional public policy issue. Many people oppose the death penalty on moral, religious, or pragmatic grounds, but the death penalty was an accepted form of punishment at the time of the adoption of the Constitution and the Bill of Rights, and this Court has affirmed its constitutionality. For many years after the nation's founding, executions were generally carried out by hanging, but states have continually searched for the most humane way of carrying out a death sentence. Beginning in the late 19th century, many states adopted electrocution. In the early 20th century, some states began to use lethal gas. Following this Court's decision in Gregg versus Georgia in 1976, which reaffirmed the constitutionality of capital punishment, many states, including the state of Oklahoma, turned to lethal injection. Like many other states, Oklahoma used three drugs that were administered in sequence. The first, sodium thiopental, induced a coma-like state, and the second and third drugs then brought about death. States used this method for some time, but eventually anti-death penalty activists successfully pressured the manufacturer of sodium thiopental to stop producing the drug. States then switched to a similar drug called pentobarbital, but the foreign manufacturer of this drug was then persuaded to block its shipment to this country for use in executions. Oklahoma and some other states then turned to midazolam as a substitute. After midazolam made this change, a number of death row inmates brought suit to challenge the constitutionality of the state's method of execution. 4 of those inmates filed a motion for a preliminary injunction against the use of midazolam. All of these men had been convicted of exceptionally heinous murders. Charles Warner murdered an 11-month-old girl after anally raping her. Benjamin Cole's 9-month-old daughter would not stop crying. He then bent her body backwards and snapped her spine in half. John Grant had been sentenced to imprisonment for 130 years. He pulled a prison employee into a mop closet and repeatedly stabbed her with a shank. Richard Glossip hired a killer who beat a sleeping victim to death with a baseball bat. These 4 men argued that Oklahoma's method of execution violates the Eighth Amendment because it involves an unacceptable risk of pain. In particular, they disputed the efficacy of midazolam. The district court conducted a 3-day evidentiary hearing and heard testimony from experts on both sides. The district court then rejected the prisoner's argument as both legally and factually flawed. The Court of Appeals for the Tenth Circuit affirmed on 2 independent grounds, and we agree with the Tenth Circuit on both counts. First, petitioners failed to identify an available alternative method of execution that involves a substantially smaller risk of severe pain. 7 years ago, in a decision called Bays versus Reese, we identified the requirements of an Eighth Amendment method of execution claim. We held that a prisoner challenging a particular method of execution must show that this method creates a risk of severe pain that is substantial when compared to a known and available alternative method. This requirement follows from the nature of a method of execution claim, as opposed to a claim that capital punishment is unconstitutional, no matter how it is administered. When a prisoner simply attacks one method of capital punishment, the court must proceed on the assumption that there is at least some available alternative method that satisfies the Eighth Amendment. Therefore, the prisoner is required to identify such a method so that the court can compare the risk of pain that this acceptable method entails with the risk inherent in the method that the state has selected. Petitioners in this case did not identify any such alternative when this case was in the district court, and they have not done so to date. This dooms their claim. When a prisoner argues that the method chosen by a state is unconstitutional, but refuses to identify an available alternative, the prisoner is arguing, in effect, that capital punishment is unconstitutional per se. That is not really a method of execution argument and must therefore be rejected. In this case, Justices Breyer and Ginsburg announced that in their view the death penalty is unconstitutional no matter how it is administered, and therefore petitioners' failure to identify an acceptable alternative to Oklahoma's method is immaterial to them. Justice Sotomayor's dissent, joined by 3 other justices, suggests that it might be unconstitutional if a state, after adopting lethal injection as its method of execution, were to go back to a more, quote, primitive method. This dissent then argues that the lethal injection protocol now used by Oklahoma is unconstitutional, even though there has been no showing that Oklahoma has any practical alternative to the use of midazolam in carrying out executions by lethal injection. Readers can judge for themselves how much distance there is between the position taken by Justices Breyer and Ginsburg and the position taken in Justice Sotomayor's dissent. In any event, because petitioners have not identified an available alternative that involves a substantially lesser risk of pain, their method of execution claim fails under Bayes. The Tenth Circuit rejected petitioners' method of execution claim for a second independent reason, namely that the district court did not commit clear error when it found as a fact that the dose of midazolam called for in the Oklahoma protocol will render a prisoner insensate to pain. This court rarely reviews a finding of fact, particularly when that finding has already been reviewed and sustained by a court of appeals. But the court granted review of this factual question, and we thus decided. A district court's finding of fact cannot be overturned by an appellate court simply because the appellate court would have made a different finding. A district court's finding of fact must be accepted unless it is clearly erroneous, and that demanding test is not met here. At the evidentiary hearing in the district court, the state's expert, the dean of Auburn University School of Pharmacy, explained that a massive 500 milligram dose of midazolam, which is many times higher than a normal therapeutic dose, is sufficient to render a person unable to feel pain. After the hearing, the district court made a finding to this effect, and that court was not alone in making such a finding. Numerous other courts have held hearings about midazolam and have also found that this drug renders inmates insensate to pain. Petitioners and Justice Sotomayor's dissent take issue with the testimony of the state's expert. I will not go into all these technical arguments, which are addressed in the opinions, but I will mention what appears to be the dissent's principal point, namely that it is irrelevant that Oklahoma administers a huge dose of midazolam because the drug has a ceiling effect. That is, at a certain point, increasing the dosage stops having any greater effect on the inmate. The district court did not err by rejecting this argument. For all the talk about ceiling effects, petitioners' experts did not show that midazolam's ceiling effect occurs below the level of a 500 milligram dose, much less that it occurs before the drug renders a person insensate to pain. The district court reviewed all the evidence presented and concluded, based on the record, that midazolam does not present an unconstitutional risk of severe pain. There is no basis to reject that factual conclusion. Petitioners make much of the fact that during the first execution in Oklahoma using a lower dose of midazolam than is at issue here, the prisoner appeared to regain consciousness during the procedure. After this disturbing incident, the state halted executions and conducted an investigation. The investigation concluded that the problem resulted from the failure to establish a proper IV line. The state then adopted new procedures to prevent a repetition of this problem and to make sure that a prisoner is fully unconscious before the second and third drugs are administered. The state has conducted an execution since that time without the occurrence of anything similar. The same is true of executions using this 3-drug protocol in another state. Petitioners and the principal dissent couch their attack on midazolam in inflammatory terms, claiming that it is tantamount to burning a prisoner at the stake. But the evidence simply does not support this rhetoric. For these two independent reasons, petitioners' Eighth Amendment claim must be rejected. Justice Scalia has filed a concurring opinion in which Justice Thomas joins. Justice Thomas has filed a concurring opinion in which Justice Scalia joins. Justice Breyer has filed a dissenting opinion in which Justice Ginsburg joins. Justice Sotomayor has filed a dissenting opinion in which Justices Ginsburg, Breyer, and Kagan join.
The Eighth Amendment prohibits the infliction of cruel and unusual punishments. Today, the Court has distorted that essential command beyond recognition. The Court's first error is factual. Oklahoma plans to execute prisoners using 3 drugs. 2 of the drugs are intended to paralyze the inmates and stop their hearts. But the drugs do so in an agonizing manner, causing burning, searing pain. It is thus critical that the first drug, called midazolam, do what it is intended to do, which is to keep the inmates unconscious. Petitioners have presented substantial evidence that midazolam cannot serve this function. The drug is not FDA approved to keep an individual unconscious during major operations, and there is scientific reason to think it cannot be used in this manner. Thus, there is a very real risk that if used in executions along with the other 2 drugs the states intend to use, the inmates may appear to be unconscious, but will actually be fully awake, yet paralyzed, slowly dying in excruciating pain. In reaching a contrary conclusion, the Court relies entirely on the assertions of a state expert witness. This testimony was premised on a complete misunderstanding of midazolam's chemical functioning that is unsupported by any scientific literature and actually contradicted by it. This misunderstanding has even been disavowed by the state itself. By nevertheless deferring to these unsupported assertions, the Court abdicates its duty to examine critically the record and leaves petitioners exposed to what may well be the chemical equivalent of being burned at the stake. I hope that states, in designing their own lethal injection protocols, will pay more heed to the compelling evidence of midazolam's inadequacy than this Court has. The second error is legal and is perhaps even more serious. This Court has long recognized that certain methods of execution are categorically off limits. But today, and for the first time, the Court turns this categorical prohibition into a conditional one. A method of execution, no matter how barbaric, will violate the Eighth Amendment if and only if the condemned inmate is able to point to another available means by which the state could kill him. Simply to describe this newly discovered rule is to demonstrate its absurdity. Under the Court's approach, it would not matter whether Oklahoma intended to use midazolam to execute the prisoners or instead intended to have them drawn and quartered, slowly tortured to death, or burned at the stake. Because the petitioners failed to prove there was an available alternative, their challenge would automatically fail. That is simply not what the Eighth Amendment says. In accepting this surreal conclusion, the Court overlooks the straightforward logic that until now guided our Eighth Amendment jurisprudence. If a state's chosen method of conducting an execution represents cruel and unusual punishment, then conducting an execution under that method will violate the Eighth Amendment. A method of execution that is barbaric or excruciatingly painful does not become any less cruel and unusual simply because there is no other method readily available. The contortions necessary to save this legal injection protocol are not worth the price. I dissent.
Well, Justice Ginsburg and I join Justice Sotomayor's dissenting opinion. We have also filed a separate dissenting opinion of our own. In that opinion, we state our belief that the time has come for the Court to again consider a more basic question, whether the death penalty itself is constitutional. Now, what has changed since the Court last asked this same question? In 1972, in Furman versus Georgia, the Court held that certain death penalty statutes were unconstitutional, primarily because of procedural inadequacies. Then, 4 years later, in Gregg versus Georgia, the Court moved in the opposite direction, finding other death penalty statutes constitutional, primarily because, in the Court's view, they contained sufficient procedural protections. Now, since that time, 40 years of experience with those procedures and protections, we believe, shows that they do not work. And for that reason, we think it highly likely that the death penalty is now violative of the Constitution. I shall highlight here briefly 4 special difficulties and considerations that 40 years of experience reveals and which the lengthy opinion we filed discusses in considerable detail. First, reliability or accuracy. Since Gregg, this Court has recognized that the, quote, finality of the death penalty creates the need for greater reliability in its imposition. Yet we now have persuasive evidence, 1, that innocent individuals have been executed. 2, that more than 100 individuals convicted of capital crimes and sentenced to death have later been fully exonerated. And 3, that the rate of procedural error in capital trials is alarming, well over 60%. Second, arbitrariness. Arbitrariness is the antithesis of the rule of law. It was the principal basis on which this Court initially concluded about 40 years ago in Furman that the death penalty, as then administered, was unconstitutional. Numerous studies have demonstrated that application of the death penalty remains arbitrary. Factors that should affect application of the death penalty often do not do so. For example, the special egregiousness of a crime. Factors that should not affect imposition of the death penalty often do so. For example, race, gender, and geography. Third, delays. The average execution last year occurred almost 18 years after the individual was sentenced to death. That's the average. This type of lengthy delay creates 2 independent constitutional problems. First, that kind of lengthy delay can itself be cruel. And second, it undermines the principal penological rationales for the death penalty. Consider that second problem of rationales. Insofar as executions take place decades after the death sentence is imposed, the execution no longer serves its basic justifying purposes, deterrence and retribution. But if executions were conducted swiftly, then we would see serious error creep in. For example, last year, Henry Lee McCollum was exonerated by DNA evidence after spending 30 years on death row. If his death sentence had been carried out in 10 or even 20 years, McCollum would not have lived to witness his exoneration. In sum, administration of the death penalty can take place swiftly but unreliably. Or it can take place with long delays, but then without significant justifying purpose. We cannot have it both ways. And given that fact, it is difficult to see how the death penalty can be reconciled with the Constitution's basic demands. Fourth, perhaps in light of the three considerations I've just mentioned, many jurisdictions within the United States have abandoned the death penalty. 19 states have abolished it, most recently Nebraska. Last year, 2014, only 7 states conducted an execution. In 43 states, there were none. Moreover, the practice is largely limited to a small and diminishing subset of counties. And the trend line is clear. Texas, for example, the state most associated with the death penalty, has seen a sharp decline. In 2013, it imposed 9 death sentences, down from 48, 15 years ago. And thus far this year, it has imposed none, not a single death sentence. I've set forth many, many more similar statistics on all these points in the opinions. I recognize that we are a court, not a legislature. But the matters I have discussed are judicial matters. They concern the infliction of an unfair, cruel, and unusual punishment upon individuals at odds with a specific constraint that the Constitution imposes upon the democratic process, namely through the Eighth Amendment. For these and additional reasons, as set forth more fully in our opinion, we respectfully dissent.
I have filed an opinion responding essentially to Justice Breyer's proposal that we abolish the death penalty. I will not burden you with that. Last Friday, 5 justices took the issue of same-sex marriage away from the people on the basis of nothing but their own policy preferences. Today, 2 justices announced their intention to have done with this court's 30-year practice of merely placing unrealistic obstacles in the path of capital punishment. You heard some of them discussed in the majority opinion today. To have done with that policy and now just honestly abolish it entirely. As it happens, unlike opposite-sex marriage, the death penalty is approved by the Constitution. You're all familiar with the provision. No person shall be deprived of life, liberty, or property without due process. Another provision requires a grand jury indictment for all capital crimes, that is, all crimes involving the death penalty. Nonetheless, these 2 justices now propose to take the issue of capital punishment entirely away from the people on the basis of nothing but their own policy preferences. I find 2 of their arguments particularly wryly amusing. One is the 18-year delay. The 18-year delay is the product of the unrealistic impediments this court has imposed to imposition of the death penalty over the past 30 years. And the fact that 19 states have abolished the death penalty is also largely attributable to the same thing. It is so expensive and it takes so long to impose the death penalty. Maybe we should celebrate the fact that 2 justices are willing to kill the death penalty outright instead of pecking it to death, as has been the case. It is not often in the law that so few have so quickly changed so much.
Justice Ginsburg has our opinion this morning in Case 13-1314, the Arizona State Legislature versus the Arizona Independent Redistricting Commission.
Several states of the United States, Arizona among them, give their citizens direct lawmaking authority, the power to adopt laws by ballot initiative, and to disapprove by referendum bills passed by the state's legislature. This case concerns use of the initiative to establish an independent commission to draw district lines for congressional elections. In 2000, Arizona voters adopted Proposition 106, an initiative aimed at meeting the problem of partisan gerrymandering, which means drawing district lines to subordinate adherents of one political party and entrench a rival party in power. Proposition 106 amended Arizona's constitution to remove redistricting authority from the Arizona legislature, which had indulged in gerrymandering. The proposition entrusts the task instead to an independent commission, the Arizona Independent Redistricting Commission. After the 2010 census, the commission adopted redistricting maps for congressional as well as state legislative districts. The Arizona legislature sued the commission in federal court, alleging that the commission and the map it adopted for congressional districts violated the Elections Clause of the U.S. Constitution. That clause, Article 1, Section 4, Clause 1, provides the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. The Arizona legislature maintained that by specifying the legislature thereof, the Elections Clause requires a state's representative body to hold the lead rein in congressional redistricting. The clause, as the legislature reads it, precludes the people from exercising the initiative to establish an independent commission to accomplish redistricting. A 3-judge district court held unanimously that the Arizona legislature had standing to sue. But dividing 2-1, the court rejected the legislature's complaint on the merits. We affirm the district court's judgment in favor of the Redistricting Commission. We hold first that the Arizona legislature has standing to bring this suit. Proposition 106 strips the legislature of its authority to draw congressional districts. Another provision of the Arizona Constitution bans efforts by the legislature to undermine the purposes of an initiative. Proposition 106 would thus nullify any vote by the legislature, now or in the future, purporting to adopt a redistricting plan. This suit, we note, is not brought by disgruntled individual members of the legislature who might well lack standing. The Arizona legislature is an institutional plaintiff, and both houses of the legislature voted to authorize the litigation. Next, the merits. We hold that both 2 U.S.C. Section 2AC and the Elections Clause permit the people of Arizona to provide for redistricting by an independent commission. This court's precedents in a trilogy of cases teach that redistricting is a legislative function. Because it is legislative, it is governed by the state's prescriptions for lawmaking. Those prescriptions, the court has held, may include the referendum and the governor's veto. While exercise of the initiative was not at issue in our prior decisions, there is no constitutional barrier to a state's empowerment of its people by embracing that form of lawmaking. Section 2AC is a law enacted by Congress specifying congressional redistricting procedures operative only if the state, after an apportionment, has not redistricted in the manner provided by the law thereof. The statute's language is virtually identical to an earlier provision contained in the 1911 Apportionment Act. That act safeguarded to each state authority to devise its own laws and regulations on the creation of congressional districts. If a state chose to lodge legislative authority over redistricting in the people, the 1911 Act supported their right to do so. So did the 1911 Act successor, Section 2AC. So long as a state has redistricted in the manner provided by its own law, the resulting redistricting plan satisfies 2AC and becomes the presumptively governing map. A statute cannot permit what the Constitution prohibits, so the question key to this controversy is whether the Elections Clause permits the people of Arizona to provide for redistricting by independent commission. The dominant purpose of the clause, the historical record bears out, was certainly not to restrict the way states enact legislation. It was to empower Congress to override state election rules and protect against abuses by state-level politicians. When the Constitution was composed and later ratified, the people's legislative prerogatives, the initiative, and the referendum were not yet in our democracy's arsenal. But is the Election Clause reasonably read to disarm states from adopting modes of lawmaking that give a direct voice to the people? We think not. It is characteristic of our federal system that states retain authority to establish their own governmental processes and to serve as laboratories for experiment in democratic governance. We resist reading the Election Clause to single out federal elections as the one area in which states may not use citizen initiatives as an alternative legislative process. The framers may not have imagined the modern initiative process, one in which the people of a state exercise legislative authority on an equal footing with the authority of an institutional legislature. But the invention of the initiative was in full harmony with the Constitution's conception of the people as the font of government power. Banning lawmaking by initiative to direct a state's method of apportioning congressional districts, as the Arizona legislature asked us to do, would have far-reaching consequences. It would cast doubt on numerous other time, place, and manner regulations governing federal elections that states have adopted by the initiative mode of legislating. To mention but one of many examples, permanent voter registration has been secured by ballot initiative. Barring the initiative could also endanger election provisions contained in state constitutions that were adopted by conventions and ratified by voters at the ballot box without involvement or approval by the legislature. Turning to the initiative to curb the practice of gerrymandering, Arizona voters sought to restore the core principle that voters should choose their representatives, not the other way around. The Election Clause, we affirm, does not hinder that endeavor. The Chief Justice has filed a dissenting opinion joined by Justices Scalia, Thomas, and Alito. Justice Scalia has filed a dissenting opinion joined by Justice Thomas. Justice Thomas has filed a dissenting opinion joined by Justice Scalia.
And Justice Scalia has our last opinion this term in case 1446, Michigan against EPA, and the consolidated cases.
These cases are here on writs of certiorari to the United States Court of Appeals for the District of Columbia Circuit. They concern whether the Environmental Protection Agency must consider the costs of regulation before imposing air pollution regulations on power plants. The Clean Air Act establishes a series of regulatory programs to control air pollution. One of these schemes, the Hazardous Air Pollutants Program, targets emissions of hazardous air pollutants from stationary sources, such as factories and refineries. The Act establishes one set of procedures governing the program's application to power plants and a different set of procedures governing its application to other sources. A source other than a power plant is covered by the program if its annual emissions exceed a specific numerical threshold, or if EPA finds that its emissions threaten human health or the environment. Power plants, by contrast, are covered by the program only if the agency finds that, these are the words of the statute, quote, regulation is appropriate and necessary, close quote. Once one of these power plants becomes subject to the program, the agency is required to impose certain minimum emissions regulations upon it. After conducting a study into emissions from power plants, EPA decided to regulate them under the Hazardous Air Pollutants Program. It found regulation appropriate within the word of the statute because, number one, power plants' emissions posed risks to human health and the environment, and two, controls were available to reduce those emissions. It found regulation necessary, the other condition in the statute, because the imposition of other Clean Air Act requirements would not suffice to eliminate those risks. EPA did not, however, consider the costs of compliance when making this decision. According to the agency's own estimates, the pollution regulations that were ultimately imposed will cost power plants $9.6 billion a year, all of which will be passed on to the consumers of electricity, of course, but will reduce emissions of hazardous air pollutants by only $4 to $6 million a year. In other words, the costs were about 2,000 times greater than the benefits. Petitioners, who include 23 states, sought review in the D.C. Circuit, claiming that EPA was required to consider cost. The Court of Appeals upheld the agency's decision, and we agreed to hear the case. Federal administrative agencies are required to engage in reasoned decision-making. It is not enough for the agency's decreed result to be within the scope of its lawful authority. The process by which it reaches the result must be rational and include consideration of the relevant factors. Here, EPA interpreted the phrase appropriate and necessary to mean that cost is not one of the relevant factors. Under familiar principles of administrative law, the administrative agency's interpretation prevails so long as it is reasonable, even if it is not the best reading of the statute. In our view, EPA's interpretation is not reasonable. One does not need to open up a dictionary to realize that appropriate and necessary is a capacious phrase. Read naturally, it requires at least some attention to cost. One would not say that it is even rational, never mind appropriate, to impose billions of dollars in economic costs in return for a few dollars in health or environmental benefits. Moreover, cost includes more than the expense of complying with a regulation. Any disadvantage could be termed a cost. EPA's interpretation precludes the agency from considering any kind of cost, including harms that the regulation might do to human health or the environment. For example, if emissions from power plants harm human health, but the technologies needed to eliminate those emissions harm human health even more, the government concedes that it would still deem that regulation was appropriate. But no regulation is appropriate if it does significantly more harm than good. Established administrative practice supports our conclusion. Agencies have long treated cost as a centrally relevant factor when deciding whether to regulate. Consideration of cost reflects the understanding that reasonable regulation ordinarily requires paying attention to the advantages and disadvantages of agency decisions. It also reflects the reality that too much wasteful expenditure on one problem may mean too little money to deal with other problems. Statutory context leads to the same place. The Clean Air Act requires EPA to perform 3 studies related to power plants, and one of those studies involves cost. Congress's express directive to the agency to study cost is a further indication of the relevance of cost to the decision to regulate. EPA argues that it need not consider cost when deciding whether to regulate power plants because it need not consider cost when deciding whether to regulate other sources. But the whole point of having a separate procedure for power plants is to treat power plants differently from other sources. Congress crafted narrow standards for the agency to apply when deciding to regulate sources apart from power plants. In general, those standards concern the volume of pollution emitted and the threat posed to human health. But Congress wrote the power plant provision more expansively, directing the agency to regulate only if regulation is appropriate and necessary. The agency's preference for symmetry cannot trump an asymmetrical statute. For these and other reasons given in our opinion, we hold that it was unreasonable for the agency to read the statute to mean that cost is irrelevant to the decision to regulate power plants. We need not and do not hold that the law unambiguously required the agency to conduct a formal cost-benefit analysis in which each advantage and disadvantage is assigned a monetary value. It will be up to the agency to decide, as always, within the limits of reasonable interpretation, how to account for cost. The judgment of the Court of Appeals for the D.C. Circuit is reversed. The cases are remanded for further proceedings. Justice Thomas has filed a concurring opinion. Justice Kagan has filed a dissent in which Justices Ginsburg, Breyer, and Sotomayor have joined.